program today. My name is Kim Stenger. I'm the head of the firm's healthcare group. Today we're going to be talking about the new Rehabilitation Act regulations. As far as written resources, you should have received links that would take you to these resources. That should have come in an email from Charles Cobbins. If you didn't receive that, you can go ahead and email Charles, or you can email me and we'll make sure that we get those to you. Some of the written resources that would be helpful are the copies of these PowerPoint slides, copies of the actual regulations themselves. I'm going to give you kind of a high overview of what the regulations contain, but really there's no substitute for actually getting in and actually looking at the regulations. And if you need further understanding, then you can look at the actual commentary that HHS issued at the time that it published the final rule. We've got the link up there for you for that also. And then HHS has published a couple of very helpful fact sheets summarizing the rules, particularly the new rules and the changes that it made to the prior regulations that existed. And you can access that at the link there on the screen. All right, a little bit of context. There's a number of discrimination laws that healthcare providers need to be worried about, including the Civil Rights Act, the Americans with Disabilities Act, the Age Discrimination Act, the Affordable Care Act, Section 1557. I would note that the Biden administration issued new rules on May 6, 2024. Those became effective July 5th on 2024. Those are the acts, the anti-discrimination provisions that apply to healthcare providers, generally all healthcare providers. We did a webinar on this a few weeks ago. If you haven't got access to that, then you can access that through our website. But today we're going to be talking about the Rehabilitation Act. The Rehabilitation Act was actually promulgated back in 1973. Section 504 is the one that prohibits discrimination against persons with disability. When the act first came out, regulations were issued that have been on the books for about 50 years, but they've never been updated. So on May 9th of 2024, HHS, the Biden administration, issued new rules. Those new rules became effective July 8th of 2024, so they are in effect now. You can access those rules at 45 CFR Part 84. Those new rules generally are drafted in ways to align with the regulations or the interpretation, the guidance that the DOJ has put out on the Americans with Disability Act. So there's not too much that is earth-shaking, but there are some new things that you have to be concerned about. Now, those are the federal laws. In addition to that, your states may have their own discrimination laws. And remember that these discrimination laws sometimes overlap, and you've got to comply with all of the applicable laws. When it comes to the Affordable Care Act, Section 1557, or the Rehab Act, they generally apply if you are a recipient of federal financial money, right? If you're participating in Medicaid or other programs, receive funding from HHS, then the government takes the position that you've got to comply with these regulations. The risk areas that you need to be concerned about are particularly with the Rehab Act or persons with disabilities. With some of the other statutes, though, it also extends to persons with limited English proficiency. It applies to sex discrimination, physical access to your facilities or equipment, websites, service animals that we'll talk a little bit more about later. So we're going to focus on the Rehab Act rule. When it comes to the Rehab Act rule, the new rules that issued covered basically the following. They emphasize that it prohibits discrimination in medical treatment decisions. It requires that care must be provided in the most integrated setting. It has new rules concerning web content, applications and kiosks, and technical compliance that you have to satisfy. It has new rules concerning accessible medical diagnostic equipment and mobility services. I'll cover those, but I also wanted to give you a brief overview of kind of what the prior rule has been, but a lot of times you don't realize that it's still there. So the Rehab Act rule, some of the other requirements are still on the books, including the requirements that you've got to have accessible facilities. You've got to make sure that your communication and telecommunication systems are accessible to persons with disabilities and comply with the rules concerning service animals. All right, when it comes to the Rehab Act rule application, it applies to recipients of federal financial assistance, which is construed very broadly. It applies to anybody who receives a grant, cooperative loan, or cooperative agreement loan contract, other than a direct federal procurement contract or a contract of insurance or guarantee, subgrant, contract under any grant or any other arrangement, blah, 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 blah. Basically, the government takes the position if you're getting money from HHS, then this Rehab Act rule is going to apply to you. The commentary that came out, the fact sheet states that it applies to federally funded and health and human services programs, such as those that in which hospitals, healthcare providers participating in CHIP and Medicaid programs, state and local human or social services agencies and nursing homes. So if you're getting federal money, there's a good chance that you're going to have to comply with these rules. Well, what does the Rehab Act rule apply to? Well, it applies to persons with disabilities, and disabilities is construed or interpreted very broadly. A person with a disability is one who has a physical or mental impairment that substantially limits one or more of the major life activities of such individual, or if they have a record of such impairment, or if they are regarded as having such impairment, whether or not they do or not. All of those situations constitute a person with disability. Under the statute, it does not apply to homosexuality or bisexuality. That's not considered a disability per se. That could trigger other provisions under Section 1557 or other statutes, but it's not a disability for purposes of the Rehab Act. The regulations specifically say that the definition of disability shall be construed broadly in favor of expansive coverage to the maximum extent permitted by the terms of this Section 504 of the Act. So it's construed. When it comes to disability, construe that very broadly. It could obviously would include persons who are deaf or blind, also those who suffer with an intellectual disability. They might have a missing limb, mobility impairment. They may suffer a significant disease like cancer, diabetes, epilepsy, HIV, long COVID, etc. They may suffer from a major depressive disorder such as bipolar, PTSD, TBI, OCD, etc. Obesity is a disability. That's one that seems to come up relatively often, but it could be anything else that is a physical or mental impairment that substantially limits one or more of the major life activities of such individual. So the commentary or the regulations themselves basically say the establishment of a disability should be a relatively low hurdle that you've almost got to assume if somebody's going to claim a disability, you've almost got to assume that they do have a disability. Okay, so the person has a disability. What does the rule prohibit? Well, it says you cannot discriminate against the person on the basis of their disability. That generally translates into that you've got to accommodate persons with a disability so as to ensure that they can access and receive the benefits of the program, services, and activities, unless under certain circumstances, for certain of the requirements, that you can show that that person poses a direct threat, or that providing that accommodation would fundamentally alter the nature of their services or impose an unreasonable burden. Now, a lot of you may think, well, it's obviously burdensome because we have to spend money to accommodate these people, but note that it's unreasonable burden, and that's a pretty high standard to satisfy. The regulations, or at least certain of the regulations, specifically confirm that if you're going to claim unreasonable burden, you're the one who has the burden of proving that it truly was unreasonable. In establishing or evaluating whether it's an unreasonable burden, you've got to consider all the recipient's resources that are available to you. And you must be that if you are going to claim that, you've got to have a written statement explaining why you think it's an unreasonable burden so that you can justify it if the government ever comes in to take a look at it. And even if you are going to limit the accommodation you're going to make because of the unreasonable burden, you've got to take other steps to maximize the benefit to the persons with the disability to the extent that you can. So as a practical matter, it's pretty hard to establish that there is a completely unreasonable burden out there. Well, what happens if you don't like that rule and so you're just simply not going to do it? Well, you could get subject to the same enforcement procedures that apply to Title VI of the Civil Rights Act, meaning that the HHS will conduct complaint investigations, usually done through the Office for Civil Rights. They can do complaint investigations or compliance reviews. The agency may force a corrective action through a settlement agreement. If you fail to agree with that, you may lose your federal funding, may not be able to participate in those programs. It's possible you could also get hit up with administrative penalties by the Department of Justice, and individuals could sue you for injunctive relief or damages, although quite often it's difficult for them to establish damages, but sometimes they'll just want to make a point, and so they'll go ahead and sue you on that. For a while there, for a few years, it seemed like the government had kind of backed off on enforcing this, but over the last 2 or 3 years, enforcement of the Rehab Act along with 1557 claims have really picked up. Usually what you'll see in these types of cases, if it's a person involving disability, you'll see claims that are not only based on the Rehab Act, but also on 1557, because there's a lot of overlap in those regulations. 1557 also prohibits discrimination on the basis of disability. When you look at some of the recent decisions that have come out there, just in October, there was the state of Maryland got hit or entered into a settlement agreement. In September, a psych hospital had to pay, or actually didn't have to pay, but entered into a settlement agreement because they failed to provide a sign language interpreter. Significantly there, in that particular decision, the court or the Office for Civil Rights concluded that they should have actually provided the sign language interpreter, that handwritten notes, lip reading, or other gestures were insufficient under those particular circumstances. We'll talk more about that a little bit later. The key point here is if you look at the recent enforcement actions over the past couple of years, really what the government does is comes in there and has you sign a settlement agreement whereby you agree to change your policies and provide additional training, that they really don't impose civil penalties. At least they haven't over the last couple of years. There was one case in March of 2023 where an OBGYN refused to request for a sign language interpreter and canceled the appointment and the patient because it wasn't worth it to him to treat the patient. Well, that provider had to pay $7,500, but that's kind of outside the norm. Usually the government's more interested in coming in and making sure that you change your policies and practices going forward. With that said, there is always a risk that you could get hit up with penalties or claims by the patient. All right, let's talk about some of the specific requirements. Under the new rules, if you have 15 or more employees, then you have to designate at least one person to coordinate the efforts to comply with the new Rehab Act rules. So you have your 1557 coordinator under the 1557 rules. You'd also have your Rehab Act coordinator. Can be the same person, could be your compliance officer, but you've got to designate this person who's in charge of ensuring that you're going to comply. And in addition, you're going to have to adopt a grievance procedure for those persons who feel that they are aggrieved because of your violations of the Rehab Act. That only applies if you have 15 or more employees. In addition, you've got to provide certain notice and signage to persons. For example, these notice and signage provisions appear throughout the regulations in different contexts, but you've got to make available information regarding the requirements under the rule as necessary to apprise your patients of the protections against disability discrimination. Unlike under 1557 and some of the others, they're not as prescriptive as to what kind of notice you've got to give. Under 1557, they actually give you a sample notice. The government's posted on that you have to give out. Not so under the Rehab Act, but you still have to provide notice. You've got to implement procedures to ensure interested persons with impaired vision or hearing can obtain the information as to the existence and location of the services, activities, and facilities that are accessible to and usable by persons with disabilities. You've got to provide signage at all inaccessible entrances, directing persons to the accessible entrance or facilities. That's kind of those, the wheelchair signs and those types of things. You've got the recipients, which are you, that provide notice concerning benefits, services, consents, etc., must take steps necessary to ensure persons with disabilities are not denied effective notice. That could be making sure that there are ways for them to get these key documents that they need in order to make sure that they can take advantage of the services. Not only that they receive them, but they can read them and understand them. All right, the next requirement is the new rules concerning medical treatment. To help understand the context, this really kind of grew out of the COVID epidemic, when, and I hate to bring up COVID again, but back in COVID, remember when there was concerns that people were running out of resources. And so hospitals and other entities would institute their crisis standard of cares to manage resources. In the context of COVID, there were a couple of decisions that came out from the Office for Civil Rights that said, hey, wait a minute, by implementing those crisis standards of care, if you are devaluing a person with disabilities, then that would violate the Rehab Act under the old standards. They've issued these new rules to make that more explicit. So, under the new rules, no person with a disability shall be subject to discrimination in medical treatment under any program or activity that receives federal financial assistance, including allocation or withdrawal of any good, benefit, or service. You cannot use any measure, assessment tool that discounts the value of life extension on the basis of disability to deny or afford unequal opportunity to qualified individuals with disabilities. Recipients cannot deny or limit clinically appropriate treatment to a qualified individual with a disability when the denial is based on bias or stereotypes, a belief that the individual will be a burden on others, or a belief that the life of an individual with a disability has lesser value than the life of a person without a disability. So where this typically comes up are situations like crisis standards of care, organ donor criteria, medical futility determinations, where you decide that, or you advocate that this person, ought not to, you got to take them off the ventilator or whatever it might be because you think that they have a poor quality of life, withdrawal of life-sustaining treatment, a conclusion that the patient is better off dead than receiving ongoing care, clinical research situations where you qualify or place conditions on their ability to participate in those clinical research programs or limit their ability to participate because of maybe some kind of disability they have. Now, it's important to note that, if they are not clinically indicated, that providing that care because of the disability indicates that it's, the care is not clinically indicated. That's different than simply having a value assessment. In the commentary, the fact sheet that came out, they gave a couple of examples of situations where this may trigger penalties. For example, violations may have occurred if you deny an autistic person with a heart transplant because of a belief that he wouldn't be able to manage postoperative care, or similarly refuse to provide treatment to a person with substance use disorder based on a belief that she would be less likely to comply with treatment protocols. Or it could be a violation if the physician refuses to provide a ventilator to a patient with Alzheimer's who has developed pneumonia simply because the physician believes that the patient's quality of life will be poor even if they recover from pneumonia. So those are the types of things that you have to be concerned about under the Rehab Act rules. All right, the next big thing, and probably the thing you're going to deal with most, are communications. Under the Rehab Act, you must take appropriate steps to ensure communications with persons and their companions. So the rules not only apply to the patient, but it also applies to companions of the patient. So even though the patient can hear fine, even though they can see fine, if their companion has a disability, then you've got to accommodate that companion. You've got to make sure that those communications are as effective as communications with others. That means generally that you've got to furnish appropriate auxiliary aids and services if it's necessary to ensure effective communication and their effective participation. The type of auxiliary aid will vary based on the circumstances. And this is kind of a big one. Under the new standards, you've got to give primary consideration to the request of a patient or companion. Now, that doesn't mean that you have to just give the person whatever they want. You still are only required to provide an accommodation that would allow them to participate as effectively. So just because they request it doesn't necessarily mean they're entitled to it. However, you're supposed to give primary consideration to their request. So the cards are kind of stacked against you. If you're not going to comply with their request, you better have a darn good reason and document that they can have effective access without, even if they don't receive the accommodation that they think that they might want. As I mentioned, this applies not only to your patients, but also their companions under the regulations is a family member, friend, or associate of an individual seeking access to a program, activity, or recipient who, along with such individual, is an appropriate person with whom the recipient should communicate. So they don't give you a lot of guidance concerning that, but just assume that if they come in with a spouse or a family member, a parent, then you need to make sure that you are accommodating that spouse or the parent, that companion, in addition to the patient. Well, what kind of auxiliary aids might you consider? Well, it's the kind of stuff that you've been dealing with for years, right? There's a long list. It's qualified interpreters on site or through video remote interpreting services, note takers, real-time computer aid, transcription services. You can use written materials, exchange of written notes, etc., etc., etc. Could be qualified readers, tape text, audio recordings, braille materials and displays, and so forth. So kind of the same stuff that you've been dealing with. When it comes to that communication, remember that the government takes the position that, hey, if you're going to do business with the government, that you agreed to accommodate these people, and it's just a cost of doing business, and therefore you can't pass those costs on to the patient. You cannot require the person to bring another individual to interpret. You can't require them to bring their own interpreter. If they do come in with somebody, with another adult accompanying the individual, then generally you cannot rely on that adult accompanying the individual to interpret, except if it's an emergency involving imminent threat and no other interpreter is available, or the individual with the disability specifically requests the accompanying adult to interpret, the person agrees to interpret, and you conclude the reliance on such person to interpret is appropriate under the circumstances. Now, that's a pretty high standard. It would allow you to rely on somebody who accompanies the patient under those circumstances if you want, but I would be very cautious about that, because quite frankly, as a separate apart from the regulations, how do you know whether or not that person's really competent to communicate? And if you can't have effective communication, how can you render effective care, get effective consent, or anything else? So I would be careful about relying. Even if the patient wants to bring in their own interpreter or have somebody interpret, you still may want to use probably would want to use your own interpreter to make sure that that they are qualified and that the information is really being communicated appropriately. Otherwise, you could have a lot of other problems that are more serious than just regulatory noncompliance. Now, that's the rule with adults. What about minors? Well, the rule specifically says you cannot rely on a minor child except in an emergency involving imminent threat and there is no other interpreter available. Hopefully that is a pretty rare circumstances. That makes sense, right? It's one thing to rely on an adult if you think it's reasonable, but you've got to assume that a minor may not be able to communicate effectively, and therefore you can't rely on a minor unless it truly is an emergency involving imminent threat and there's no one else available. Most of the time, you're going to rely on, some kind of video remote interpreting service. In those situations, the regulations state if you rely on qualified interpreters via video remote interpreting services, you've got to ensure that you have the appropriate technology. You've got to have real-time full motion video and audio over appropriate connection that provides high quality video images. It's got to provide a sharply delineated image large enough for both parties to see each other's face, arms, hands, and fingers so they can tell the communication that's going on. It's got to be clear, audible transmission of voices, and the persons who are using the technology have to be adequately trained to ensure that that communication system is really working and that there is effective communication. In the case of telecommunications, if you're going to use telephones and communicating with patients, then you've got to use text telephones, TTYs, or equally effective system to ensure communication with persons who are deaf or hard of hearing or who have a speech impediment. If you're going to use an automated attendance system, such as voicemail and messaging, you've got to provide an alternative, a way for real-time communication with the person using auxiliary aids so that they can reach a live person to communicate. Well, what about kiosks? This is a new rule. A lot of healthcare entities are going to the use of kiosks to not only check out from stores, but you're also using the kiosk to check in for appointments and things like that. The government wants to make sure that those kiosks are accessible. So under the new standards, no qualified person with or an individual with a disability shall, on the basis of that disability, be denied the benefits of or otherwise be subjected to discrimination under any program or activity of a recipient provided through kiosks. You got to make sure those kiosks are accessible or that they have a means to avoid the kiosk. So you can comply with by ensuring that the kiosks they use are accessible to people with disabilities, or by implementing procedures that allow people with disabilities who cannot use kiosks to basically bypass the kiosks and go directly to a person to receive the help that they need. All right, let's talk about the web and mobile accessibility. Everything's going to the web, right? Because of that, the government needs to make sure, or wants to make sure now, that your websites are accessible. And the government has established these web content accessibility guidance, the WCAG. I don't know whether it's WCAG or what, but so the government has these standards for web content. So effective May 11, 2026, so you've got about a year and a half. If you have 15 or more employees, then you've got to ensure that your web content and mobile apps comply with those web content accessibility guidance. So you've got about a year and a half to get that in place. If by the following year, by May 10th, 2027, all entities, even if you've got less than 15 employees, you've got to make sure that your web content and your apps comply with those government accessibility standards. Now, there are certain exceptions. You don't have to do that if doing so would result in the fundamental alteration of the program or undue financial administrative burdens. But remember, you've got the burden of establishing that it was an unreasonable burden, and that's kind of a tough standard to satisfy. There are exceptions for archived web content that satisfies certain conditions. So if it's old stuff that you're not using anymore, you don't have to go back and update archive stuff. Pre-existing conventional electronic documents that are not currently used in the program, current content posted by a third party, unless you control the content. So maybe you contract with a vendor or somebody else to provide that content for you. Then in that situation, the government expects you to require in your contract with that entity that they are going to, whatever they post is going to comply with these new standards. Password protected content about an individual doesn't have to satisfy the new standards, but you've still got to make sure that you're accommodating persons with disabilities. Social media posts that predate the deadline specified above, then you don't have to go back and fix those. Or if you can establish that the non-compliance with those web content standards has a minimal impact on the access. So work with your website developers, your IT people, make sure that they understand these new rules that are coming down the pipe effective May 11, 2026. All right, what about accessibility standards? This is the rule that applies to your physical facilities, right? They generally have to be accessible to persons with disabilities. Now, these rules have been on the books for a long time. So, they began applying back in 1977. Essentially, now the rule is that if you're going to have new construction or alterations, you need to make sure that your construction or alterations are consistent with the current applicable accessibility standards. Your architect or your contractor should know those. You just want to make sure that they're going to make those changes consistent with the current accessibility standards. Note that if you are a public entity, that the standards for public entities are different than private entities. So make sure that you're using the right standards when it comes to those accessibility issues. The new rule does address mobility devices, so people on a scooter or using a wheelchair. Generally, you must allow individuals with mobility disabilities to use manually powered aids in areas open to the pedestrians, such as wheelchairs, walkers, crutches, etc. You need to set up your systems, your facilities to allow their use. In addition, you have to allow power-driven mobility devices unless you can demonstrate that the class of device cannot be operated in accordance with legitimate safety requirements, considering things like the type of equipment it is, the size, its weight, the speed of the device, so it's not running over people in the hallways, the facility's volume of pedestrian traffic, facility design and operation, safety measures, and so forth. When it comes to persons who come in and want to use a mobility device, You generally may not ask the person using the device about the nature or extent of their disability, but you can ask for confirmation that the device is required because of a disability. All right, here's a new rule concerning accessible medical equipment that you're going to need to comply. The government was concerned about situations where a patient has a disability, maybe they're obese and therefore they can't get access or can't use your medically diagnostic equipment. So, under the new rules, you may not discriminate against persons with disabilities in the use of medical diagnostic equipment or MDEs, such as exam tables, exam chairs, weight scales, mammography equipment, x-ray machines, and other radiological equipment, etc. So, under the new rules, they established a scoping standard. So, you've got to make sure that you provide a minimum level of these accessible medically diagnostic equipment. So the way the rule works, all MDE purchased, leased, or if you've got a lease that's renewed after July 8th of this year, you've got to make sure that that equipment, even if it's equipment that you renew the lease on, that it satisfies the standards for accessible MDE under the government's rules, under their standards, unless and until the scoping standards set forth below are satisfied. Okay? If you use the MDE, at least 10%, but no fewer than one of each type of the MDE must meet the standards. If you are a program that specializes in treating mobility, at least 20%, but no fewer than one of each type of the MDE must meet the standards. So the way that this works is effective now, right? If you're going to go out and purchase, lease, or renew a lease for this equipment, you've got to make sure that either that equipment satisfies the standards, or you've got to, if you satisfy the scoping standards, so if the equipment that you've got, at least 10% of your equipment, but no fewer than one of each type of the MDE, if that satisfies it, if you satisfy that scoping standard, then the new stuff that you get doesn't have to satisfy it. But until you do satisfy that scoping standard, then any of the new stuff that you get has to satisfy those standards. Okay? If your stuff does not work or you've got concerns, then you still got to take reasonable steps to accommodate those individuals with a disability. Some things you may consider would be reassignment of the services to an alternative or accessible locations where they can get the care that they need or have access to that medically diagnostic equipment. Maybe arrange for home visits, delivery of services at alternative access sites, or purchase, lease, or otherwise acquire the accessible MDE. So that's going to require, especially a lot of you smaller physician offices, you're going to have to go back and look at your, if you use MDE, you're going to have to make sure that it's going to be accessible or up until the time that you're able to satisfy those scoping standards. Similarly, for exam tables, they want to make sure if you're using exam tables by July 8th of 2026, so again, you've got about another year or 2 years, that if you use an exam table, you've got to have at least one exam table that meets those MDE standards that would, for example, accommodate persons who are obese or otherwise have a disability. Similarly, if you use a weight scale, you've got to have at least one weight scale that meets the MDE standards. The government is giving you a couple of years in order to get that in place. They realize it may be somewhat of a burden for some of you, so they figure if you've got 2 years, then you can budget accordingly and make sure that you get that in place. And that applies to anybody who's using an exam table or a weight scale. All right, that is a quick summary of what the rehab rules require. Just in short, as far as the deadlines, so effective now, effective July 8th of 2024, you cannot discriminate based on disability. That generally means you've got to provide meaningful access to persons with disability. That's providing facility accessibility, interpreters, auxiliary aids, service animals, etc. Any newly purchased or leased medical diagnostic equipment must meet those accessibility standards unless you otherwise satisfy the scoping standards. Those scoping standards are at least one or at least 10%, but no fewer than one of the MDE must meet those standards of accessibility. By May of next year, if you have 15 or more employees, you got to make sure that your web content and mobile apps comply with the WCAG standards. By July 8th of 2026, you've got to make sure that you have at least one exam table and weight scale that must meet the standards for accessible MDE if you use an exam table and a weight scale. And by May of 2027, all recipients, even if you've got less than 15 employees, you've got to make sure that your web content and mobile apps comply with those standards. All right, let's talk briefly about service animals. I get a surprising number of calls about service animals. When we're talking about service animals, just remember, for the purpose of the federal regulations, that's dogs. It's not your peacock. It's not your whatever it is that you see on the social media. Comfort animals are not service animals. A service animal is a dog. A service animal is a dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or mental disability, which works or tasks must be directly related to the disability. Now, miniature horses are not defined as service animals, but they get basically the same protection under the regulations. A miniature horse effectively is treated like it was a service animal if that miniature horse has been individually trained to work or perform tasks for individuals with disabilities. Again, it's dogs or miniature horses. That's it. It's not other animals, and it's not animals simply because they provide emotional support, comfort, or companionship. Instead, they have to be trained to do a work or perform a task directly related to the disability. What are the rules for service animals? You must permit the person with disability to use the service animal unless the service animal is out of control and the handler does not take effective action to control it, or the service animal is not housebroken. If they don't control it or it's not housebroken, then you're not required to allow the use. You must allow the service animal to accompany the individual with the disability in all areas where the members of the public, participants in the programs, or invitees are allowed to go. For example, service animals usually are allowed in areas such as admissions and discharge offices, emergency rooms, inpatient and outpatient rooms, examining and diagnostic rooms, clinics, rehab therapy areas, cafeteria and vending areas, pharmacy, restrooms, and all other areas of the facility where healthcare personnel, patients, and visitors are permitted without added precautions. But you may generally exclude the service animal from limited access areas that employ general infection control measures, such as operating rooms, burn units, those types of things. The rules for service animals under the Rehab Act rules generally require track the ADA rules. The DOJ has published some very helpful guidance concerning service animals. You could call that up and you're usually going to be okay under the Rehab Act rules. When it comes to service animals, you may not ask the patient about the nature or extent of the person's disability. If they require a service animal, the only thing that you can ask is two questions. You can ask, is the animal required because of a disability, and what work or task the animal is trained to perform? So you can't ask them what their disability is, but you can ask them what work or task the animal is trained to perform. You may not ask for documentation or proof that the service animal has been certified, trained, or licensed as a service animal. You've got to assume that they have been. You may not require payment of a surcharge because they're using a service animal, but you may require payment for damage if the other persons with pets are required to pay for damage. The service animals must be under the control of a handler. That generally means that they've got to have a harness, leash, or other tether unless the person's disability prevents the handler from using one of those, or doing so interferes with the service animal's voice, work, or task. Under the control of the handler could, in addition to having the harness or the leash, it could be voice control signals or other effective means of control that would satisfy that requirement. Note that you are not responsible for caring for the supervision of the service animal if the patient brings them in, or if the patient's an inpatient in the facility. It's not your job to take care of the animal, but you have to reasonably accommodate. You could allow family or friend to come in and care for the animal while the animal's at the facility. For more information about the service animals, as I mentioned, you can go to the ADA's website, and it's got good information and guidance concerning service animal issues. All right, for additional resources about the things we've talked about today, you can go to this website. This is the government's new website that specifically talks about the new Section 504 rules. Among other things, it's got a copy of the rules, the fact sheet, and a detailed fact sheet. I think there's also a YouTube video out there that summarizes these rules. In addition, you can go to our website and you'll be able to access a copy of this recording as well as the written materials that we provided for you. For those of you who missed the 1557 presentation or the materials that we published, the articles and stuff we published on 1557 discrimination, you can go to this website and you can access all of that for free also. That's it. That's a brief summary of the rehab rules. I hope it's helpful. If you have any questions, feel free to go ahead and submit those using the chat feature, or you can send me an email offline. But otherwise, I hope you all have a good week.